There's fly excrement all over the walls and the furnishings. You can see that there are just tons and tons of animals huddled together here, there, and everywhere. So that is actually very helpful to do, and they do videos and they do a lot of photographs, especially when they're taking the animals. They're photographing them where they're found and photographing them when they are taken into the ASPCA for examination.
Okay, great. And then that comes once we've gotten the ASPCA or some other kind of inspection going inside the home. So the hoarders, to get into the home in the first place, a lot of times it's happening through tips. Are people using these photographs and videos somehow, maybe family members or friends, to get a warrant?
Yes,
to get into
that's exactly what happens.
Okay.
To get the warrant, and they'll come to me for the warrant.
Okay.
Yes, and that's how we get it.
Okay. Thank you. Okay, one more question from the front row.
Yeah, I was wondering, in other boroughs, I don't know how long it is in Queens, it can take a year or more between arrest and trial. Are you ever able to get a restraining order that prevents the defendant from having animals or making contact with animals? And if they are convicted, how long are you able to get lifetime bans on animals, or is it just a limited period?
It's usually a limited period in terms of bans, and under the registry that we have in New York City, it's a 5-year ban on a misdemeanor and 10-year ban for a second offense or some felonies. We have not so far gotten a prejudgment order banning animals, but that could certainly be made as a condition of bail. If bail was going to be set, and we could say that would be a condition of bail if they not have any animals. And so it does take, it's unfortunate because I'm certain in the case that I have that there must be a boatload more of animals there as we speak. And there was no bail set in the case, so I couldn't get it as a condition of bail.
Thank you.
Okay.
Okay, so we are going to change over to our next speaker, and then there will be plenty of time for questions afterwards, after all three have spoken. So for those of you that didn't get your question asked right now, hold off please until the end of the presentation. With that, I will, we're going to do a musical chairs here. And the next up is Mickey Osterreicher. Mickey Osterreicher is of counsel to Barclay Damon LLP in the Media and First Amendment Law Practice area and serves as general counsel to the National Press Photographers Association. He's on the governing board of the American Bar Association Communications Law Forum, co-chair of the Fair Use Committee of the American Bar Association Intellectual Property Law Committee, a member of the New York State Bar Association's Media Law Committee, the Media Law Resource Center, News Gathering Committee, and the First Amendment Lawyers Association. As a lawyer, Mr. Osterreicher is actively involved in such issues as cameras in the courtroom, the federal shield law, media access, public photography, ag-gag legislation, anti-paparazzi statutes, drones, copyright, fair use, and orphan works. He has provided training regarding First, Fourth, and 14th Amendment issues to law enforcement agencies and associations throughout the United States, and has moderated and participated in panels nationwide, speaking about the right to photograph and record in the public. Currently, he's been in the past an adjunct lecturer in photojournalism at the State University of New York at Buffalo and an adjunct law professor in media and the law at the University at Buffalo Law School. He graduated cum laude in 1973 from SUNY of Buffalo with a Bachelor of Science degree in photojournalism and photography and received his Juris Doctor cum laude from the University of Buffalo Law School in 1998. He's admitted to practice in New York State, U.S. District Court for the Western District of New York, and the U.S. Supreme Court. So please welcome our next speaker.
Thanks for having me. The one thing I'll add, not that you need more, but I was a photojournalist in both print and broadcast for about 40 years. So it's something that lawyers have. Their most difficult job is understanding what their clients do. Fortunately, I've done it long enough and have been doing it so that they don't have to explain things to me. So I'm going to be talking about ag-gag, and that basically is more rather than animal abuse. It's animal abuse on a much broader scale, usually either by farmers or large agricultural countries and the gag part is to prevent people from learning about that. So we have been involved. You know, photographers are violent people. First they frame you, then they shoot you, and then they hang you on a wall. So, you know, nowadays everybody's got a camera, because everybody's got a cell phone, and almost all of them have cameras in it. So it really has changed the game. Just in 8 years, between 2005, 2013, the exact same spot. Anybody want to guess what's going on here? Well, they're waiting for the next pope to be named. And in the first one, everybody's waiting patiently. In the second one, they're not holding up candles. Those are the glowing screens of their phones. And actually, in the foreground, there's an iPad, if you can see it. So anyway, but how does all of this come into play? The Bill of Rights has a number of amendments to the Constitution, the first one being the First Amendment. And there are a number of clauses to that, but we're going to focus on just a few of them. The freedom of speech, freedom of the press, the right to peaceably assemble, and to petition the government for a redress of grievances. And those all come into play, especially when we're dealing with ag-gag. But the First Amendment is an absolute. It's subject to reasonable time, place, and manner restrictions, and as most things in the law, the key word is reasonable. But there's also some further restrictions. The restrictions must be content neutral, they must be narrowly tailored to serve a significant governmental interest, they must leave open reasonable alternative avenues of communication. And we'll see how all of that comes into play when we deal with some of these issues. Fourth Amendment, obviously against unreasonable search and seizure, at least when we're dealing with this, aside from the arrest of a person, which is the seizure of their body, is oftentimes the seizure of their equipment. So that becomes a factor. And then the 14th Amendment, where we deal with due process and equal protection of the laws. One of the main cases in terms of ag-gag and animal rights is the United States versus Stevens. And the U.S. government, under the U.S. Code, criminalized the commercial production, sale, or possession of depictions of cruelty to animals, but the Supreme Court ruled that that was an unconstitutional free speech abridgment. So the Congress went back and they refined the law. The case that had been brought, this guy had actually done some videos of dogfighting, not to show or glamorize it, but to just show what went on. It was more of a documentary, and he was prosecuted under that law, and that's why the case went up to the Supreme Court. Congress went back, and they basically said the types of videos were narrowed down to crush videos. So just like child pornography is a certain type of speech and communication, and that's one thing I'll talk about. So remember I said free speech? The press is obvious, but we're talking about photography, videography. Well, those two things have been deemed to be forms of expression, and if you can't express yourself, you can't have free speech. So that's how photography and videography is covered by the First Amendment. So clearly, depictions of animal cruelty are most likely offensive to any reasonable person, but the court had to balance the social costs and benefits and could not justify the restrictions. Now, it was interesting because we filed an amicus in this case, because even with the act that itself, in terms of the language, they had an exemption for videos that had a religious, political, scientific, educational, journalistic, historical, or artistic value. And even with that exemption in there, the court still struck down the law as restricting more speech than was necessary to achieve a significant governmental purpose. I know I'm going fast and I'm touching on a lot of legal issues. I realize most of you here are not lawyers, and hopefully I'll be able to answer questions as we go on. So other things that we deal with, and hopefully you'll see the similarities, is Steven Tyler, who's a resident of Hawaii. You might know him as the lead singer from a rock group. He basically tried to have an anti-paparazzi measure put into place in Hawaii. When you're out on the street, there's no reasonable expectation of privacy. That's a given. When you're in your home, you have the greatest degree and expectation of privacy, which is why if you see something that's out on the street and clearly visible, you can take a picture of it, you can record it, you don't need permission to do that. You can take another person's picture and record them. Now, they may not like it, and if you hold them up to public ridicule, they might, you might be subject to defamation. But in terms of what the law allows in this country, for example, in France, you need permission to take anybody's picture in public, but not in this country. So Steven Tyler was trying to get an act created in Hawaii where when he was out in public with his family, nobody could take his picture or record him. And this was the bill that was proposed, and it basically addressed depictions of persons engaged in a personal or familial activity. Because it regulated expression, it was presumptively invalid. At least that was our position. The First Amendment, as we just talked about in Stevens, has permitted few restrictions on historic categories of speech, including obscenity, defamation, fraud, incitement, and speech integral to criminal conduct. So those are the areas that the courts have said, yes, on its face, those can be restricted. They didn't want to add to that. So we had visual images of sound recordings or other physical impressions of another person who is out in public where there's no reasonable expectation of privacy must not be added to that list. And you would include in that now depictions of animal cruelty. If you're standing in a public place and you can see, as we'll see in a case that's coming up, depictions of cruelty to animals, you can photograph and record them. The problem here is that this law imposed civil penalties of alarming breadth and burdened substantially more speech than was necessary, again, to achieve a governmental interest. While we recognize the right of privacy, and this is part of a letter that I wrote to the legislators, we oppose broadening those protections by abridging the clearly established tenets of First Amendment jurisprudence. The bill, even though Steven Tyler testified, Halle Berry testified, it didn't get anywhere. This is basically what the legislator said. There is zero support for that. There were some of them that were very starstruck, but I love the quote, there's a better chance of people flapping their arms and flying from Lanai to Maui. Fortunately, the bill didn't go anywhere. Not so much in California. They ended up having an anti-paparazzi bill. Another thing that we deal with, and that I deal with a lot, is drones. Again, if you can take a picture on the ground and there's no reasonable expectation of privacy, we don't believe that just because the technology is changed and there's a camera on this new device, that should change the way the law is and the way privacy is. But in New Hampshire, they were looking at what they call critical infrastructure. And they didn't want people to be able to conduct surveillance, as they called it, without prior consent of any person. So now all of a sudden, you've got to get somebody's permission. So imagine I'm standing with my camera, and I'm taking a picture of you. Now there's a drone hovering at the exact same height, and it's got a camera on it. All of a sudden, because you were operating the drone, that would require permission. So we've been opposed to that and pretty successful. Again, they had language that you had to have a horizontal distance of 500 feet or a vertical distance of 400 feet. The problem with that is you couldn't be closer than 400 feet to the bridge vertically, but the FAA says you can't fly above 400 feet, period. So it's kind of hard, and that's one of the problems that we're seeing with a number of the state legislations dealing with this. But I'm just trying to show you how these all kind of interplay to one another. California passed an anti-drone measure. Again, I wrote to the governor and talked about the fact that the California legislation poses a serious risk to uses by journalists to gather and disseminate the news to the public, and the public's right to receive news is guaranteed by the First Amendment to the U.S. Constitution and Article 1 of the California Constitution. The chilling legal repercussions of this bill will tax an overburdened court system and thwart the federal government's efforts in which we are participating to bring about a sensible regulatory regime for this new technology, and the governor basically took some of that wording in his veto message. Those are all the media companies that signed on to that letter. So we were pretty fortunate in having that not happen, but, you know, every year there's new legislation. So now we're finally going to get to some of the ag-gag. Utah passed an ag-gag bill. And a woman was standing on a public street where she observed some goings-on at an agricultural site, and she took photos of it. The owner of the site called the police came, and they arrested her under the ag-gag bill. Problem was, the language of that bill talked about being trespassing. She wasn't trespassing, she was on a public place where she could clearly see what she was taking pictures of. And fortunately, after the media got a lot of play on this, literally the prosecutors dropped the charges the next day. So this is what the Utah code looks like. Recording an image or sound by leaving a recording device, so that's like if you sneak a recording device onto somebody's property without the consent of the owner. Obtaining access to an agricultural operation under false pretenses. There are a number of investigators and animal rights groups that have had members of their group go in under false pretenses and become employees of these organizations just to do that type of investigation. Applying for employment here, again, that was a different part of it. And then recording an image or sound without the consent of the owner while committing criminal trespass. Well, she didn't meet any of the elements of that, which is one of the reasons why they dropped the charges. We have submitted an amicus brief along with the Reporters Committee for Freedom of the Press and some other media groups. There's a constitutional challenge to that bill right now. And we urge them to say that the statute is unconstitutional under the First Amendment as well as the 14th Amendment. And, you know, think about so many things that have come to light by investigative journalism. Having this bill on the books and being an active statute would chill free speech, freedom of the press, matters of public concern. It would really impinge on the marketplace of ideas, which must remain robust so that people understand what's going on. New York. I'd like to tell you that New York in 2012 tried to introduce an ag-gag bill. Fortunately, again, it was defeated. But they would have criminalized unauthorized video and audio recordings of or photography done without the farm owner's written consent. Well, you know, most people are not going to consent, especially if they think that there's something going on that they don't want anybody to see. Again, this bill was so broadly written that it included photography or recording that could be made from public property. And again, the language of the bill was any structure, building, vehicle, pasture, paddock, pond, impoundment area, land, or property upon which farm animals are housed, cared for, grazed, or bred. So again, it was overly broad, and the fine would be imprisonment or a fine up to $1,000. Another ag-gag bill that was in Idaho, and it was struck down. And this is what the judge had to say. Although the state may not agree with the message certain groups seek to convey about Idaho's agricultural production facilities, such as releasing secretly recorded videos of animal abuse to the internet and calling for boycotts, it cannot deny such groups equal protection of the laws in their exercise of their right to free speech. So that's how the 14th and the First Amendment come into play in the court's decision to strike down the ag-gag law in Idaho. In Tennessee, there was another bill. It had been passed by both houses, wrote a letter, had a number of groups sign on to it. Fortunately, the letter went to the Attorney General of the state, and the governor, in his veto message, cited the Attorney General's report, which called the bill's provisions constitutionally suspect, at least with regard to the First Amendment. Another problem in some of these laws is that there's mandatory reporting. So you take some photos or recordings of what you believe is animal abuse. the way the language is written is that you then must report to the police and the owner of the property what it is you've done. There are shield laws in most states that protect journalists from revealing their sources and their material before it's published. So again, the governor noted that, and we drew his attention to the fact that the language of this bill was in conflict with the Tennessee shield law, and that was another reason that he vetoed it. Right now, we have joined with a number of animal rights groups in Wyoming because they have what's known as the Wyoming Data Trespass Bill. Fancy name, it's still an ag bill. And basically, the bill made it illegal to collect resource data. What's resource data? What's collection? From any land outside of city boundaries where that land, whether that land be private, public, or federal. All of a sudden, remember what I said? You're out in public, no reasonable expectation of privacy, you're allowed to do it. We're sitting there looking at this law going, gee, that's interesting, because they're saying it could be public land and you still can't do it. And collect to them means to take a sample of material, acquire, gather, photograph, or otherwise preserve information in any form from open land which is submitted or intended to be submitted to any agency of the state or federal government. It's like a great way to stop whistleblowers. Just criminalize the fact that if you do it, you're going to be in trouble. Well, fortunately, the judge in the first round found it our way, and basically he confirmed that the plaintiffs had standing to challenge the laws, because at first they said the National Press Photographers and some of these other agencies and animal rights groups did not have standing. He said they were. And then he found that there were serious concerns and questions as to the constitutionality of various provisions of these trespass statutes, and that the state's argument for ag laws appeared to simply be a facade for content or viewpoint discrimination. Remember, in terms of First Amendment, what I said is it has to be content neutral. Here, they're not happy about some of the messages that are being conveyed by these images. That it has to be neutral. It's like whatever the image shows, that needs to stand. If it's one kind of image versus another kind, that's where bills like this get into trouble. So, we see a chilling effect on free speech. These are overly broad, they're vague. They encourage self-incrimination. If you have to go turn yourself in and report what you've seen and photographed and then be in violation of the law, well, that's dealing with the Fifth Amendment in terms of self-incrimination. Again, a lot of them are content-based. They don't leave open other alternative avenues of communication. They're not reasonable time, place, and manner restrictions because they restrict more speech than necessary. And again, they fail to provide equal protection or due process. And now you've had a kind of whirlwind view of, three parts of the Bill of Rights. So.
Thank you, Nick. Do we have any specific questions for you based on his presentation? Yes.
At a public protest on the street, if I'm taking video footage of someone who's yelling at us because we're protesting, and that person says, you do not have my consent to photograph me or videotape me, and then I take that video of that person saying that and I include it in the video of the protest, what are there laws around that?
No. If they don't want to be photographed or videotaped, they should stay home with the windows shut.
So if YouTube is a private company, can you, if that person then files a complaint against a privacy complaint with YouTube and says,
Most of the time, the only time things come down under the DMCA, the Digital Millennium Copyright Act, is for a copyright violation. You're not invading their privacy if they're in a public place. So unless they have a copyright interest, and if you recorded it and it was in a fixed medium, you're the copyright holder.
But legally, is the YouTube allowed to pull it down because YouTube is a private company and can just make a decision?
No, you could file a counterclaim to that and have them put it back up.
Okay.
But yeah, again, think about the fact that every day we're outside. We're photographed and recorded scores of times. There's surveillance cameras all over the place. The reason for that Once again, is there no reasonable expectation of privacy in a public place? Whether that pertains to dash cams in police cars, body cams that policemen will start to wear, your camera in your hand.
The Google car.
Yeah, the Google car. So hopefully that answers that question. I'm sure they won't be satisfied with your answer. And hopefully, if the police get called, they get it, which is why I spend a lot of time trying to train them, but some of them don't get it. Go ahead.
Thank you, James.
I have a question about is there any expectation of privacy if it's a child that's they're outside, they're with their family, they're at a public event, then you take that and put it in like a newsletter or something about that event?
Well, it really depends on how you use it. So it's kind of two distinct things. One is the right to take the pictures. What you do with them afterwards could become a problem. And I unfortunately find in the climate that we live in, when I was a photographer and I was wandering around and, taking pictures back in the 70s and 80s, nobody, if I would tell people, hey, I'm with the newspaper or I'm with the TV station, and go, okay, but nowadays I cannot tell you how many times photographers, especially if they're in a park or something with their children, parents freak out about anybody with a camera. So it's unfortunate that we live in that climate, but could you use that picture of the child for an advertisement for Hasbro toys? No. They would have a cause of action because you've used it commercially without a model release, so forth. But if you're using it, taking it because it's a cute picture and you like kids, no.
I have two questions specifically for you. One is for photographers that are hired as undercover investigators for groups like Mercy for Animals or Compassion Over Killing that go in. Where is with whatever they get, where is the liability right now for the nonprofit group that hires these photographers or documenters? Is there any law happening right now about that you?
Well, it really depends on if you're in a state that's got an ag bill and it criminalizes the fact that you've gone in on false pretenses.
Does it go back to?
Let's put it this way. Most lawyers pretty much sue everybody that they can sue and then let them sort it out. So in this case, I would think that they would have a good argument that this person is acting as an agent for them, and certainly they would have liability as well. Whether they're found liable at the end of the day, I don't know.
So it becomes an agent versus an independent contractor kind of?
Even if you're an independent contractor versus an employee, you're still an agent, so.
Okay. Secondly, there's a lot of talk, and people are enthusiastic about the idea of using drones to get up high over factory farms specifically and be able to document certain things that we don't really have access to, especially in state ag if we're going to wind up with, putting humans at risk for prosecution under that. What's the status or what's your sense about the use of drones going over these pretty much remote areas where we don't really have access to and getting some pictures of stuff happening there from up top?
So there's a couple of things going on. The FAA is in charge of the safe integration. They were mandated by Congress back in 2012 for the safe integration of UAS, unmanned aerial systems, that's what the fancy name is for drones, into the national airspace. And the deadline that the Congress set was September 30th, 2015. If you check your watches, you can see that we're way past that time. There's an interim rule now which says a number of things, but the interim rule can't be challenged until it becomes final. They keep saying that the final rule is imminent. That doesn't mean it won't be subject to challenge, but they're talking about sometime either this month or next month for them to issue the final rule. The FAA pretty much says that they control all the airspace. In the meantime, in the absence of them creating a final rule, a lot of states have created this patchwork of rules. Think about it this way. If every municipality went to the rules of the road were completely different from one place to another. So hopefully the federal preemption will prevail and we'll have a better idea. The second component of that is the NTIA, the National Telecommunications and Information Agency was mandated by the president to deal with privacy issues, because the FAA was having enough trouble dealing with the safety issues, let alone being tasked with privacy. And I was one of the stakeholders and went to meetings where they're talking about, and we just finally developed best practices for the use of drones in terms of the privacy issues. The one thing that we were adamant about is that those best practices do not apply to the First Amendment protects news gathering and free speech from those best practices. So if you're dealing with a state that has a law that says you can't fly over someone's property without permission, and you're in particular flying over an area that you normally couldn't see from any other place other than the air, you know, there could be an argument made that that person had a reasonable expectation of privacy in that area. This is all going to be played out. I mean, one of my favorite stories is the fact that in the late 1800s, when George Eastman invented the Brownie camera, this was the first time that people could have a camera in their hand, cheap, $1, take it out in the street and photograph. Because before that, you either were Matthew Brady, that had a big covered wagon and huge cameras, and schlepped all the stuff around to take pictures, or you went into a photographer studio and you put your neck in a brace and you held still for 5 minutes for them to make an exposure. And pretty much everyone was saying the right to privacy as we know it is over, late 1800s. There were signs up, no brownies at the beach. Think about the fact that people wore more to the beach then than they wear to church now. Didn't matter. And so Louis Brandeis and Samuel Warren were both Harvard law students. Louis Brandeis went on to become a Supreme Court justice. But if you Google the right to privacy, it's an essay that they wrote. And if you read it, you will think they're talking about drones, because they talk about the snooping press and the nosy neighbors and the fact that, oh my God, you know, but the law eventually, the law of privacy eventually caught up with technology. It always does. The biggest problem right now is back then, the technology kind of plodded along and the law caught up. Now technology moves at this exponential rate. The regulatory stuff moves at a glacial rate. The divide gets wider, but eventually, I don't know if it'll be in my lifetime, but it'll catch up. So.
Thank you so much, everyone, thank you, Mickey. I do want to say that we're really grateful to have him as part of the panel tonight, because Mickey mentioned that he comes from this photojournalism as well as the law background, and I do want to just mention that his work has been really all over the place. He's been in the New York Times, he's been in Time Magazine, and Newsweek, and USA Today. So he really adds to that, coming from that, the creative community's expression about what's happening and how these photography things can be used for good, and also the challenges that they're facing today, especially with technology and laws coming up that you know, could really kind of get in the way of being able to use it to its greatest extent and for the betterment of our own communities.
And this isn't a plug, but if you happen to be watching, because it starts to air